resume the recording and stop the sharing. So good evening, everyone, and welcome to the Washington Foreign Law Society series, Issue and Trend in International Anti-Corruption Law, Part 2, organized by the Washington Foreign Law Society. This is the second of the two events. If you missed Part 1, please go to our website under Past Event for the recording of December 10. I'm Juliana Canet, the president of the Washington Foreign Law Society, founded in 1952 to promote knowledge and understanding of international legal matter, comparative legal issues, and foreign law. Given the number of participants tonight, you will be muted, but able to communicate with our distinguished panelists via the Q&A section. Please do send the question throughout the seminar, so at the end of it, we can get to your question. And thank you for all for sending already question in advance. Let me introduce our moderator for tonight, Pascal Hélène Desbois, International Executive Advisor, Independent Expert, Adjunct Professor at Georgetown University Law Center, and member of the Washington Foreign Law Society Board. One final note before I hand the floor to Pascal. Please consider becoming a member of the Society. We have discount rate for $25 for students and discount rate for government employees. During the panel, I will send you a link in the chat so you can directly go and become a member as sustaining our great programming offer. Welcome, Pascal. The floor is yours.
Thank you, Juliana. So we only have an hour, so I'll jump right into it. I'll first ask the question to Wim, introduce him, and then the same thing with Jonathan. So Wim, you're a professor of business ethics at the University of Greenwich, a well-known expert in the area of whistleblowing. You're the convener for ISO 37002, which is the international standard for whistleblowing management systems. You're also the co-director of the Center of Research of Employment and Work at the University of Greenwich, and you're the editor-in-chief of, I really like that, Philosophy of Management by Springer. And you've written several books on whistleblowing and also several articles. Welcome to the event, and you're in Europe, so it's very late for you. Really appreciate you staying up for joining this panel. So we'll start with the basics, and that is, what is whistleblowing? And let's talk about some real life examples. Over to you, and welcome again.
Well, thank you, and first of all, thank you for inviting me to this onto this webinar to have a conversation with you and Jonathan. If you ask what is whistleblowing, I am an academic, so I'll give you the standard academic definition, and one which I've been working with for many years. That's by Micheli and Neer, and it says, whistleblowing is disclosure by an organizational member, current or former, so it's a disclosure by them, about illegal, illegitimate, or unethical practices falling under responsibility of the organization, and it's a disclosure to someone who can affect action. So it's a very broad definition, but the key thing is that the whistleblower wants to stop wrongdoing, but does not have the mandate or does not have the power to do it. So it calls upon someone else to do that. That's definition of whistleblower. I said it's really broad. So to give you some examples, the first one from a technology multinational company. Whistleblower was someone working in HR. I'm not going to name them because she's been reinstated, and I don't want this to have a bad effect on her. But her concern was that the way the company was engaging staff through email, and specifically times at which this happened, was actually a form of indirect discrimination, and hence was breaching the law. That conflict escalated, and she took it to Employment Tribunal, won the case. But a second example would be an ethics officer at a humanitarian aid organization. I'm talking about Helen Evans at Oxfam. I don't know if you know this, but she had repeatedly raised concern with her board that there was not enough. She did not have enough resources to investigate internal reports about sexual harassment It fell on deaf ears. She went to the regulator. Nothing happened. She went to the regulator again a year and a half later. Nothing happened. She eventually took it to the press, and it was, at least here in UK, was a pretty big scandal. A third one, still in the news, although the whistleblowing happened in 2012, would be Jonathan Taylor, a whistleblower exposing bribery in the oil industry, but then got arrested 9 months ago in Croatia. And this happened on an Interpol red notice, but apparently he's not accused of anything. So this is typically, well, not typically, but yeah, this is the kind of retaliation that also happens. So it's very diverse. But I think we need a definition, and I need an understanding to that covers that whole range in which whistleblowing can occur.
Thank you. Thank you. That is, and it's good to have a broad definition. And so we'll give more examples. Turning over to you, Jonathan. So you're an adjunct professor at both Georgetown University Law Center and also American University. And we can see the background. You know, you're showing your AU colors tonight. You're the in your day job, you're the principal of DTG Risk and Compliance. You were a federal prosecutor for 26 years in the fraud section of the U.S. Department of Justice's Criminal Division, and you are also a senior fellow with the Program of Corporate Compliance and Enforcement at NYU. And you're also working with the University of Maryland Center. And at another point in your life, you were senior VP and head of anti-bribery and corruption at Wells Fargo. So same as Wim, you know, very important and interesting resume. Very welcome to this program tonight. So you represented a whistleblower in Africa. Can you tell us about the situation again, so that we set out the issues for the audience tonight?
Certainly, Pascal, and thanks to the Society for giving me and Wim the chance to talk about these issues. My situation, which basically involved pro bono representation, occurred last year. In Mali, our professor Clément Dembélé, who was a candidate for president of the country at one point, but has been a longtime anti-corruption activist, delivered a video to the people of Mali in the local common language Bambara rather than French. And in addition to, as he had been for some time, calling out the regime for pervasive corruption, he also highlighted some comments to the police and army in Mali, because there were worries at the time that, given anti-corruption demonstrations in the country, that police or soldiers might use weapons, as sadly they had done about 20 years ago, that led to numerous deaths. So he made some comments that were basically, you know, please align yourself with the people and not against them, and do what's in the best interest of the Malian people and not in the interest of a few corrupted politicians. So within a day, he was accosted by people who were hooded, unmarked uniforms, unmarked vehicles, armed with submachine guns. They basically abducted him from the street, and for roughly 12 days held him in complete incommunicado status. A lightless cell, no one speaking to him, a hood over his head, and other things. He luckily was not tortured. A number of people who knew the professor, well acquainted with him and supported his cause, started to speak up through French channels. And eventually I was able to speak up on behalf of his wife in a pro bono capacity. I basically sent a detailed argument to the government of Mali saying, all these things you have done are a violation of your own constitution, your own code of criminal procedure. And happily, not that it was all due to me, he was released from custody within a day. And thereafter, I think the government looked hard at the flimsiness of their charges and let it all go. So this, unfortunately, is an example of a situation where perhaps had I not tried to do something to speak up in a formal way as a lawyer speaking on behalf of this individual who was incommunicado, who knows how many more weeks or even months he might have been held, but for the additional pressure that came through a variety of countries, through their departments of foreign affairs and whatever modest help I gave. But it is also a reflection of the larger risks that public whistleblowers can take in countries that don't have effective protections for people who simply want to be advocates against corruption or to blow the whistle on actual complicity in corruption by high officials.
Did it again. Okay. So I recently listened to a panel on the state of FCPA, and Jessica Tillipman, who's a professor was actually the dean of government procurement at GW Law, was saying that employees who have recently been laid off because of the pandemic may be disgruntled and may more likely become whistleblowers. Somebody on that panel was also saying that people are hurting financially, and that it's more likely to become a whistleblower when there are financial rewards. That's what I heard on the panel. And there is the SEC bounty program, which is doling out quite a bit of money. Somebody else that I was listening to said that now that the employees are at home, it's actually a lot easier to record conversations. It's easier to have your phone next to you and record than bring in the phone and record conversations of illicit behavior in the workplace. Now, I use that for provocation because, of course, as we all know, not everybody becomes a whistleblower because of money. At the same time, because people are mostly at home these days, they're removed from the fray. Maybe they can think more carefully and having a bit more distance and not under the daily influence of their work environment. And maybe that is what is making them bolder to become whistleblowers. And so there were actually some government people on that panel who were saying that in their experience, most people blow the whistle first internally, and when they don't get what they hoped they were getting, that's when they go outside. So this is the intro to the next topic, which is motivation, right? Why do whistleblowers blow the whistle? Why do companies and countries adopt a whistleblowing program and rules and regulations? And we'll start with Wim. What are the motivations for whistleblowers?
Okay, well, I was just, when you were telling the story about, the crisis, people more disgruntled, they're going to become whistleblowers. I was thinking, a crisis is always a good situation to fire your internal whistleblowers and, get rid of them. So, hey, there's a very broad brush statement to go against that. But, to be serious, I always approach whistleblowing. I see it as a very protracted process. It's not a one-off decision. So it actually starts with someone asking that difficult question or raising a concern, sometimes directly with the person they see as the wrongdoer, or the immediate, or the line manager. But then very often that they get neglected, or they get a weird response. It's like, oh, mind your own business, or you don't have to worry about that. And that gets them thinking, like, what is going on? They try to raise again internally. If they already start feeling some retaliation, they might use the hotline. But eventually, if things can escalate, and then, yes, people blow the whistle to a regulator. So I think the motivation is really, it's determined by the real or the anticipated response that someone with a concern is getting, or what they anticipate they are going to get as a response there. So I think, that's really motivation. And I'm giving you a difficult answer, and perhaps that is because I'm approaching this from a European context where, the question about motivation and in a lot of legislation that we've seen in Europe, there's always this good faith requirement. And it is so unproductive. It's so unhelpful. And it's a really good thing that, thanks to a lot of civil society organizations who've also been very lobbying very hard for that. First in UK, then in the Principles of Council of Europe, and also in the EU directive. The good faith is not in there. It's not in there. But that has been a very tough fight. So people, I know that there's always questions, and this is Washington D.C. Foreign Law Society, but there's going to be questions around financial rewards on whistleblowing, and the real fight in Europe is let's get this good faith requirement out of the game here. So I'm always a bit this is always my reaction when you ask about motivation of whistleblowers. It's irrelevant, or it should be irrelevant.
Thank you. Very, very interesting. Turning it over to Jonathan, what is in your experience? What have you observed as motivations for whistleblowers?
Well, Pascal, I think the points that Wim made are very pertinent here as well. I think you almost have to think of two phases of somebody being a whistleblower. That is, somebody who sees something that he or she thinks is clearly wrong in violation of a corporate policy, a federal regulation, a federal agency requirement, for example, and they think, I should report this to someone. So they use the proper channels. Lots of agencies, lots of companies say, we want you to report wrongdoing, etc. But too often what's happened is people try to use those channels and their pleas are ignored. Even when they say, I can give you details, this isn't just, supposition on my part. And so when they see that there's no effective remedy within their company, within their agency, then they have to make the more difficult decision to go externally, whether it's directly to the press or in some other way, perhaps by litigating in court. And when we talk about motivation, one of the things that I suspect a lot of whistleblower advocates and whistleblower attorneys, that is those who represent whistleblowers, will say is when they're counseling potential whistleblowers, you'd better expect that you will not have a job again in that company or that agency, and maybe not a job ever again. The retaliatory motive, in other words, in some environments can be so strong. The leaders, the senior executives or whoever who set the tone of non-compliance, the tone of, if you're not with us, you're against us, can frankly not only taint that person's chances for reinstatement or fair treatment within the enterprise, it may also have a spillover effect, because once you become known as a whistleblower, even today, I think a lot of people regard whistleblower as a pejorative term. Oh, you're somebody who went outside, you didn't play by the rules, you leaked information. Like all these pejorative statements can effectively bring your employability to an end. And that has happened in time after time after time with whistleblowers. So when we talk about the financial motive for whistleblowers, part of the motivation may be, I may never have a job again. And if this is what my company or my agency or my government has done to me, I have a right to be able to fend for myself. I have a right to be able to feed my family, make sure they have a roof over my head, because I've done nothing wrong. I didn't create false documents. I didn't, pay bribes. I didn't do other things that my company or my agency or my government should never have done. And so in some respects, particularly in those legal regimes where there isn't an effective judicial remedy, some kind of whistleblower award may be the only compensation that whistleblower ever gets that helps him or her to support themselves potentially for years after they finally go public.
Correct. No, and this is a good segue into protections for whistleblowers and what protections there are around the world. So are we better off today than we were 10 years ago? And what is the difference too between Europe, for instance? I'll start with Wim first, and then John, if you can talk us to what is happening in the US. So both, are we better off, and what is on the books these days? Wim, over to you.
Okay, well, but are we better off? The short answer is yes, but
Yeah.
if I can expand on that, we should be naive, and yes, there is better legislation, but let's not be naive. I gave you the example of Jonathan Taylor. I mean, yeah, the Serious Fraud Office in the UK has actually successfully taken action based on Jonathan Taylor's information, on his whistleblowing. Yet Jonathan Taylor is arrested in Croatia, fighting his extradition to Monaco. I mean, it's complete bonkers. No one is impressed with the British diplomacy. I mean, why aren't they getting Jonathan Taylor out of there? Come on, this is and so this is yeah, it's totally bonkers. But we also have in the DRC, Republic of Congo, there's 2 whistleblowers that have received the death penalty for their whistleblowing. So I mean, yes, we've always heard, I think for the past 30, 40 years, the stories about how whistleblowers get intimidated, right? You get phone calls and they say, "Oh, we know we know when your daughter or your son needs to go, when their hours are at school, etc." Those kind of intimidations, but it's always hidden. But here we see, with Jonathan Taylor, what's happening in the DRC. These are courts and that actually, fully legitimately intimidate whistleblowers. There's a lot to do around these, they call it SLAP, strategic lawsuits against public participation, intimidating journalists, intimidating people who assist whistleblowers. So this is, we're getting better whistleblowing legislation, and at the same time, it's a very, very tough fight. But I think, apart from better legislation, what we also have, compared to 10 years ago, we now also have much better civil society organizations that are real experts on this. And so, I mean, you've got an amazing one in Washington, D.C., Government Accountability Project. And Tom Devine, Samantha Feinstein, Donna Gold from GAP, they're doing excellent work, not just for US whistleblowers, but actually helping civil society organizations in other countries as well. We've got the Whistleblowing International Network, Blueprint for Free Speech, Transparency International, and also the Media Freedom Rapid Response Team. That's something new, and it works great. So in that sense, we are in a better place. If I can tell you a little bit about the legislation that's coming then in Europe. So there is an EU directive on whistleblower protection. It came into force in November 2019. When you have an EU directive, it means that 27 member states need to transpose that directive into their national legislation. So they have time until the end of this year. I think a lot will be quite late. TI and WIN just published a report on what's the status of the transposition. It's not that good news. It tends to be quite slow. And what we see is that the real discussions around who can you blow the whistle to and be protected, good faith, and how broad is this? All the discussions that people had when the EU directive needed to be passed, they seem to be, we need to have them again in each of the 27 countries. So that's tough, but I think eventually, we'll see each of the 27 member states improving their whistleblowing legislation. Some already had it, but it was just public sector, not private sector, or it didn't cover whistleblowing to the press, all kinds of things. So that will be improved, and a lot of countries will. It will be totally new. So just I think the key points here would be that there is protection for whistleblowing at 3 levels. Meaning internal whistleblowing is protected also when you blow the whistle to a regulator. and there is no mandatory sequence. You don't have to go inside first before you go to a regulator. That was a tough fight, but they eventually won it. And also whistleblowing to the media. Very important there. There is a reversal of burden of proof. So if the whistleblower can argue that it is plausible that they experienced retaliation for their whistleblowing, then the employer needs to prove it didn't play a role. It's a big deal because even in the UK, the reversal burden of proof, yes, but the employer needs to prove that whistleblowing wasn't the main reason, which is quite easy. Okay, so we need a real reversal of burden of proof, that the employer needs to prove that the whistleblowing played no part in whatever detriment, that someone being dismissed or missing a promotion, whatever. So that's an important one. The notion of worker is pretty wide, so it does cover agency workers, trainees, interns, fixed term contracts as well. So that's good. And the EU directive itself covers wrongdoing of any wrongdoing relating to EU law. Now that there's a lot there. There's consumer protection, transport safety, environment, food safety, privacy, etc. So yeah, I think that's really in a nutshell what's coming in the EU 27 countries, and that is going to be quite a big change.
Thank you for that. So John, how different is it in the US?
Well, I'd say for starters that, to use a kind of homely metaphor, what Wim has described across the EU is basically a single blanket that covers all of the EU. Some may say it's a thin blanket, but it is a unified approach, a single garment, if you like. In the United States, by contrast, we have been putting together a patchwork quilt with varying sizes of patches for literally just over half a century. The very first country in the world, apparently, to enact any kind of federal whistleblower protection was the United States in 1970, during the administration of President Richard Nixon. But it was a very specific one dealing with occupational safety and health issues. And since then, the US federal government has enacted something like 60 different whistleblower laws, all of them with different standards and different effectiveness. So to this day, we still have a largely patchwork approach, although the Whistleblower Act that the Securities and Exchange Commission is able to use as a vehicle for people to encourage whistleblowers to come forward regarding misconduct by publicly traded companies, has actually been one of the more powerful vehicles to get whistleblowers to come forward and through their whistleblower reward program to give them substantial financial incentives, substantial rewards based on the size of the overall sanction that the SEC imposes. Now, if you look at the overall experience in the United States, and here I should cite specifically a very recent report by the International Bar Association and the Government Accountability Project that looked at whistleblower laws around the world and how well they're doing. You might say, when you say, are we doing better than we did before? Yes, I would agree with Wim. It's certainly the case in the United States. We do, in fact, have some measures of success. According to the IBA GAP report, a little over 10% of all federal and 31% of corporate employees formally won retaliation claims, and an even larger percentage obtained informal relief. And again, according to the IBA GAP report, there is a good bit of transparency and public access to information that allows more complete analysis of what's happening with whistleblowing. At the same time, the report also says, if we actually look at the number of disclosures that get referred for investigation and the number of substantiated cases, that's low. Unfortunately, while lots of people seize on these 6-figure and even 7-figure whistleblower rewards that come through some of the SEC's bigger cases, the reality is that volumes and volumes of cases end up going uninvestigated or unsubstantiated. And to add further to the difficulties here, there's also very little consistency in reporting or tracking of information. Even the US Congress, which you would think would want to make sure that people come forward to report to it if there's problems of some sort where they could legislate, even the US Congress's system for tracking what happens with disclosures that are made to Congress basically is a non-existent system. So there are plenty of areas on which the US can certainly improve. I would add, since Wim talked about potential legal developments in the EU, I think one of the interesting things that I would be very curious to see is what happens under the recently enacted Anti-Money Laundering Act of 2020. That substantially expands the whistleblower award program that the Treasury Department can bring. And now it's sort of brought it into the same criteria that the SEC uses for whistleblowing, so that the Treasury Department is required, not just has the discretion to, has to pay an award of up to 30% of what was collected, where there's a monetary sanction of over $1 million. And as long as the whistleblower voluntarily provided original information that led to a successful enforcement action, and that could be criminal prosecution or civil enforcement, for example, against financial institutions, that could be a significantly greater incentive for people to come forward to report on these kinds of issues. So plenty of room for improvement on the US side, but it is interesting to see that there's, in certain important sectors, a growing willingness by Congress and the executive branch to value the worth of these kinds of reward programs and to encourage more whistleblowers to come forward.
Thank you. So in terms of an ideal system, say that a country would come to you and would say, please help me put in place the most ideal whistleblowing legislation. We can always keep dreaming, right? What would you suggest would be in those laws as compared to what we see right now? So we'll go back. Start with you, John, and then go to Wim. And maybe Wim, at that time too, you've been following whistleblowing regulations around the world. You've mentioned the EU. Perhaps you can also compare it, what John just said, to other countries or regions that you're familiar with. So, John, an ideal whistleblowing system.
I would start by telling another country, well, first of all, you have to make the distinction. Are you trying to encourage whistleblowing in the government sector as well as the private sector? And if you have that capacity, you need to make sure that your whistleblowing criteria and your approaches are similar for the public and private sectors. I mean, obviously, you may not want to have finely grained regulations on how individual companies should structure a program, but you could create basic requirements. You will have a whistleblower program. You will have a program that requires effective response to and redress of significant grievances, significant problems. And as part of that, I would say, part of the reason people choose to go public and blow the whistle is that their employer has basically stonewalled them, has not given them a fair opportunity to report and to let the matter be handled internally. So I would say, don't just think about a whistleblower law, think about what you are doing as a government to maximize the commitment of your agencies and your private sector entities to a program of integrity. So that means you ought to be trying to encourage people to bring things to the attention of that agency or that company internally and give them confidence that they will be treated seriously. That, unfortunately, has been the pattern over and over and over, both in government agencies and in private companies in the United States. Lots of companies and agencies have paid lip service to the notion of, oh, of course we want people to come forward. Of course we want you to be able to bring wrongdoer attention, but they don't mean it in practice. And so really what you're saying is, if you want to have fewer public whistleblower cases, you need to have better internal mechanisms that give people confidence that things really work. I will say, because it's a matter of public record, one of the things that led to these titanic fines and penalties that Wells Fargo has suffered since 2016 stemmed from the fact that when people who saw some real problems with internal behaviors, mistreatment of customers, tried to use their internal reporting system as it existed at the time, those reports were funneled back directly to the same people who were responsible for causing the misconduct, and those people got fired. Had happened over and over and over. And again, just a matter of public record, literally up until 2016, one of the key senior executives in that company had not fully disclosed to her own board of directors how many people had been fired on these spurious grounds. So I start by saying, you want a whistleblower program, that's great, but start at the foundations. And then if you find, as will inevitably happen, some agency head, some senior executive of a company decides that certain things can't be talked about or certain things can't be questioned, then make sure you have an effective mechanism that provides prompt attention, validation, of course. You can't necessarily just take people's word. You have to have some degree of checking out of the allegations, but then show that you have an effective mechanism that treats people fairly and takes action as appropriate. The citations I gave to you before, they sound sort of good in practice. I'm willing to bet that if things work better at various agencies and companies, those numbers on people who successfully got redress for their grievances would be a lot higher. So, I would conclude by saying you want to make sure that in your government, you have an agency that will take these allegations seriously, not shunt them off to the side, not ignore them. And if you believe that these are merited allegations, then you have to have an effective mechanism, either for that whistleblower to be able to bring suit in court himself or herself, or for your government to stand in their shoes, as we kind of have with our qui tam litigation process.
Okay, yeah.
And then the government becomes the one to speak up for those who are trying to bring these types of wrongdoing to attention and did not get fairly treated.
Thank you. So, Wim, this would be a good opportunity also to weave in already a question that we had received because it links to this particular topic, and then you can weave in the answer. So this is a question received from John Kostiak of the National Whistleblowers Center. With the Dodd-Frank Act, the US has created a successful model of protecting and incentivizing whistleblowers and evidence of private corruption. The three key ingredients appear to be: 1, dedicated whistleblower office charged with investigating disclosures and educating potential whistleblowers; 2, confidential and anonymous disclosure opportunities for whistleblowers; and 3, financial rewards drawn from sanctions recovered thanks to the whistleblower. Do you agree with that formula for success? And can you explain why we see it in so few other countries?
Yeah, I think, we see it in very few other countries. I think at the moment there are 17 countries that have some kind of program that offers financial rewards to whistleblowers. So the financial rewards by themselves are not the success formula, and I appreciate that that there were 3 conditions, and I think the combination of those 3 would be is important. I think there's another one, and it's sort of because what Jonathan was saying about the importance of an agency that actually does something with this. I think that is the other condition. You actually need a regulator who runs these programs, who really wants to use their mandate, to use whistleblowing information to actually enforce some action. And I think that is what is really missing outside of the US. I mean, if I'm thinking if I'm thinking about Australia, for example, because this whole idea of protection at 3 tiers and successive whistleblowing, and originally I think this was early 90s. That's an Australian idea, so, and again, at this moment, the proactive protection of whistleblowers at the internal stage, something that's part of the ISO standard, but it's an Australian idea. ASIC, the Australian regulator, they've got a regulatory guidance that was issued in November 2019. It's really good. And it really drives for that kind of really good internal procedures, not just a policy, not just a nice poster on the wall, but actually, it's like, what does that entail? If you're going to protect people, make a risk assessment as soon as a report is made. Don't wait until the whistleblower says, I'm experiencing retaliation. It seems very normal, or it seems very basic, but actually, that it is in whistleblowing context that is quite new. So you see a lot of good ideas originating in Australia. They amended the Corporations Act as well, good legislation. But what's missing is is an agency that has a broad enough mandate, and who has the will and the guts to actually, show its teeth and bite. And I think we have the same problem in Europe. I'm hopeful, of course. I'm an optimist. I'm hopeful that in Europe we'll see a model where there is as new whistleblowing legislation comes into force, it will actually also create or mandate a government agency to be able to take up whistleblower reports. But the important thing is that it needs to have teeth and it needs to want to bite. I'm hopeful that, perhaps I'm naive, but I think the country to watch here in Europe would be France. Okay, the Sapin 2 legislation, it had, it had some good whistleblowing provisions, including it was tough on breaches of confidentiality. When you breach the confidentiality of the whistleblower, it had criminal sanctions for retaliation. So that was a new one for Europe. It's going to be broadened. It will now also, so the mandatory sequence of reporting will go away with the transposition of the EU directive. So you have that. You have a national ombudsman who reports to Parliament, who is able to refer to regulators to investigate, to follow up. So there's that aspect as well. And you have a new anti-corruption agency, the AFA, Agence Française Anticorruption, who this is, it's my guess, but it looks to me like, this new agency really wants to make a change. It really wants to put itself on the map. You get your ex-president convicted for corruption. That's I think it's well, okay, Pascal, but it's more than we were used to see. So I'm hopeful. I'm hopeful that in a whistleblowing context, that could be the model. But perhaps I'm overly optimistic.
So it's interesting to see that. It was very interesting, John, to hear that the US were the first ones, to put this law on the map, right? And then to see that in Europe, everybody's watching to see how it's going to get transposed. I have been reading quite a bit about what is happening in France, and it's true that also, the link with Sapin 2, with their equivalent, the French equivalent to the Foreign Corrupt Practices Act. Now, picking up on one of the questions that I saw, which I think fits here very nicely. We've been discussing what would be an ideal situation, but what happens in a country where corruption is endemic, right? So in the States, in Europe, and other OECD countries, one has really seen in the past several years a distinct push, right, to do something about both local corruption and transnational corruption. But what about those countries where you're just saying, oh my God, what are we gonna do now? When things are endemic. Starting with John and then Wim.
Well, I would say, Pascal, that for starters, if you have anti-corruption activists, NGOs inside that country that knows it's got pervasive corruption, their best course of action, I think, in the shorter term is to try to build connections and networks with supportive governments and NGOs outside their country. I mean, that's, realistically, there's no point in petitioning the government because the government will ignore you. Even with my client, Professor Dambele, I mean, he was a longtime activist, but he was also a respected public figure and a professor. So he was, he had credibility in multiple channels, so to speak. But he was lucky in one sense that, in part because of Mali's historic connection to France, not only did he have a lot of friends in business and other lines of employment in France, there were actual demonstrations in Paris. There were people speaking up through business organizations back to the Malian government saying, wait a minute, this isn't right, this is excessive. And again, a happenstance point here, I heard about this through a network of anti-corruption people and thought, having no expertise at all, I can assure you, in Malian criminal procedure, let me see if there's something I can do. And as it turns out, all the stars shone at the right times. I was able to make contact with his wife, did all the right things, and things moved very quickly. But I think, especially in these situations where, like the point that Wim mentioned earlier in the DRC, where even the judiciary apparently is complicit in suppressing whistleblowing information, it may be that some of those networks that civil society organizations in that corrupt country have to set up are not just, what can you do to support us from outside? Can you speak up on our behalf? But if we get arrested, if we get detained, if we are taken off the streets, can we in effect have an emergency procedure to find lawyers, either in country or otherwise, who can immediately be engaged to start speaking on behalf of that person? Of course, there are extreme situations, as we now see in Russia with Navalny, where the government will never respond to any outside pressure, unless I miss my guess. But in other countries, there is that chance. And the last thing I would say here, I have to speak a little guardedly about this. With the right advocacy in the right places, you can get other governments to engage sub rosa, but in a formal way with the government where this corruption is going on, and say, you need to do something about this. Lots of countries have signed to things like the UN Convention Against Corruption, and lots of people pay lip service to their international commitments. But sometimes you have to use these informal networks and informal relationships, in the short term at least, to try to get leverage and at least make a bad situation less bad.
I think you're quite right that the professor that you helped was lucky because he found you and you were able to help him, but he was also somebody well known, right? And somebody who already had contacts. So Wim, it would be great, because we also said in the title that we were going to speak about it. If you could speak a little bit about legal and financial assistance for most people, right? Not a famous person in a particular jurisdiction who has a lot of contacts, because the majority of people, and as you both pointed out, it's not an easy thing, right, to blow the whistle. So what is available? And speak a little bit about the press, because when we were prepping, you mentioned the press, and there is a big link with making sure that you get help when you go to the press.
Yeah. So first on the legal assistance, with a colleague of mine at the University of Greenwich, we did research into 4 years of whistleblowing cases in the UK. They are heard at an employment tribunal. So 4 years of all cases heard at employment tribunal, and we looked at the strength of representation of the whistleblower claimant and the employer defendant, and the imbalance in power. And it was the most important variable that determined whether the whistleblower whether their case was going to be dismissed, or whether it was going to be successful or not. So legal support, it really, really matters, because you have a lot of people who are litigants in person, who represent themselves. and you know, against against
Not a
an
good idea.
organization who has a whole team of lawyers. So it can get very tough. So that is very important. I think I'm hopeful that with the EU directive, of course, it won't apply to the UK, but in other countries that we're going to get, there is some provision in there that countries must provide some legal support. So that, you know, whistleblowers, if they need to go to court, that they get some legal advice. It's currently done, but it's not as part of legislation. It's civil society who organizes it. It's done in Ireland by Transparency International, or Integrity and Work in Ireland. It's done in the UK by a number of civil society organizations. Whistleblowers UK is one of them. Protect is another one. So I think that is really important. I think one element that would be on my wish list when you get to, you know, the ideal whistleblowing legislation would also be that judges who are going to hear these cases need to get training. Need to understand, you know, what's behind all this, what kind of dynamics are actually real. Because sometimes a whistleblower's story is, you know, if they would turn it into a movie, you'd say, like, really a bit far-fetched. You know, I still remember a whistleblower who is actually the person who got me doing research. He was saying, Wim, you know, you watch a movie, you think it's totally crazy. You want to see reality multiplied by 10. You know, it's like that. So I think a training for judges really would also be important. I think, you know, training for journalists might be another one, because, you know, you asked about the press as well. I think there's a lot of misconceptions about you know, what journalists do when whistleblowers approach them. Also with whistleblowers, you hear a lot of whistleblowers who are actually disappointed because, you know, they thought, I go to a journalist, they're going to bring my story. And very often they don't, because they don't think there's a story in there. Nevertheless, I think, you know, we really need journalists. And for people who are in very difficult position, if a journalist actually brings your story and keeps you in the press, that can actually save your life. So it is really important. Without free press, you don't have rule of law. Without rule of law, you don't have freedom. It's as simple as that. So free press is really important. But the whistleblower needs someone to guide them, to say, okay, here's the journalist you need to talk to, right? This is what you need to give the journalist, this kind of information. Otherwise, how will they know there's a story there? You know, just, you know, whistleblower and then journalists, they don't really match automatically. You need someone to actually assist them and guide them.
Thank you for that. Juliana, I'm looking at the time and we've got 4 minutes left, and I'm looking at my list of questions here. I think we've woven in your remarks pretty much, you know, answers to all the questions. But there's one here that I want to ask, and that is, this is from, so I was looking at the list of people that ask questions in advance, and now I want to pick another one from the people that are asking now. Why limit the definition of whistleblowers to those who work for an organization where the wrongdoing has been detected? Because if you're looking at the US law for securities fraud, you know, the bounty law of the SEC, it can come from people within an organization where the misconduct has occurred, but also people outside the organization. So maybe, Juliana, with your permission, we'll use that one as the last question to be answered. Jonathan, we'll start with you, and then we'll finish with Wim.
Well, I think I start by saying, I think the general level of success that the Securities and Exchange Commission has had through the Office of the Whistleblower demonstrates the value of a broad definition. I mean, of course, it makes sense that as a core, you want to encourage insiders who become aware of certain things to be able to use the whistleblower program if there's no effective internal opportunity for redress and effective response. But why limit yourself if you really want people who have knowledge to speak out, to say, well, you must only be in this employment category or that employment category. I mean, as long as somebody has information that proves to be credible, it shouldn't matter. I think this is the emerging perspective in US law generally. It shouldn't matter whether that person is currently an employee or currently an executive or currently an official at such and such company or agency. Do they have information that's relevant, credible, worthy of follow-up? And if that's the case, and they are therefore entitled, one, to legal protections as a result of their whistleblowing, and two, some kind of financial reward for having had the willingness to come forward, I think the broader definition is a better one for public policy and a better one to encourage greater use of whistleblowing laws.
Wim?
No, yeah, I agree. I mean, it's going to come over like I'm a fan of Sapandeur. I'm not. Just the interesting thing in Sapandeur is just a natural person. Okay, it doesn't talk about work context, but you certainly, I mean, whoever asked that question, it certainly really has a good point. And we used to think about very specific work contexts. And in 2018, I did some work for UNODC and the International Olympic Committee, writing a sort of handbook on reporting mechanisms in sports organizations. And it was lovely working with the experts and the investigators who work with whistleblowers in a sports context. And then it really dawned on me that in a sports context, I mean, you can have athletes, but yeah, are they workers or not? I mean, they can be minors who are actually the whistleblowers, or it's parents of it's parents of your worker who blow the whistle. So yes, we really need to broaden it up. Absolutely, yeah, good point.
Thank you. Any last things that you want to make sure before we hand it over to Juliana, that you want to make sure that we don't miss telling the audience about particular points? Yeah, go ahead.
The only thing I'll mention here, since I referred to it, I've just sent through chat a link to that IBA gap report. I think many of you who are on this webinar will find a lot of interesting material. It's a very, very broad survey around the world. So it's not just US oriented or even European oriented. It's quite comprehensive and very thoughtful in its approach. So I commend it to your attention.
I agree. It's a great report. Thanks for mentioning that. Wim?
Yeah, I think it is a great report, and the people who've wrote it put in a lot of work into that. But it's a fabulous piece of work. I just wanted to reinforce the point that we can have really good legislation. We can have a strong agency or regulator. But the third really important player here is going to be civil society organizations to make sure everyone stays awake on this. So that is also going to be really, really important going forward.
Absolutely. And whether one talks corruption, anti-corruption in general, or whistleblowing as a way to uproot corruption and do something about it, civil society are always a very important stakeholder in the sense that they keep all of us on our toes and honest, and they have, they're well equipped to do that as part of their mandate. So thanks for pointing that out. I would like to say thank you for all the questions that we received from the audience before today's event and also during the event. Thank you very much to Wim and John. This was great preparing, and I really appreciate your remarks. So Juliana, back to you.
Thank you so much. Thank you for the attendees. You will see the recording soon on our website. And please join us on other future events. We have already 3 lineup. So be a friend of the society and watch and consult our website. Have a great evening. Bye-bye.
Thank you. Bye.
Bye.